Okay.
Good morning. I'm Jonathan Turner, and sitting next to me is Alfredo Ortega, and we are presenting on the topic of Dynamex and I guess another related topic of Dynamex on steroids as codified by AB5. There has been a lot of questions by our clients and by other people who are just versed in employment and labor practice and who want to make sure that their clients are being properly serviced by looking at how people are being classified and what kind of working arrangements are going to pass muster under the new laws. Just by way of background, I think the people who have logged on, we can't see who you are, but I'm assuming that you were given some information about the summary of what we're talking about today. Our governor had signed into law September of this year, AB5, which codifies the Dynamex decision. And the Dynamex decision, I'm sure most of you know, is a California Supreme Court decision. It was a unanimous opinion that issued back in April of last year, and it basically sets out what they've referred to as the ABC test to determine when a worker is considered an employee versus an independent contractor. That test was borrowed from the Massachusetts jurisdiction. I think there were some other states in the country that also had been using this test in some form or another. But the interesting thing about how this test was dropped into the court's analysis in the Dynamex case is none of the parties that were litigating the Dynamex. And by the way, I think, I want to catch myself, I think the proper pronunciations is Dynamics. If I fall back to Dynamex, sorry about that. I'm just so used to it.
It is Dynamics.
Okay. But the interesting thing is that the parties who were actually litigating the case before the Supreme Court had not advanced any arguments regarding the ABC test. This was something that the court just basically pulled out on its own and decided that this was how they were going to determine when workers are going to be considered employees, because they felt, and I think they freely admitted that. You can look at the very first paragraph of the court's opinion, and I think it's very clear they were engaged in social engineering to try to put into place an analysis that would make sure that businesses are paying their fair share of employment taxes, that employees or workers who are maybe given some opportunity to set their own hours and working conditions are still under the overall reality of their arrangement, subject to the hiring party's business, and therefore should be given the protections that exist under the very numerous labor statutes that exist in our great state. So I think that's what the court's intention was. That's what they really have focused on. And they have basically said with the ABC test, and this is probably going to be a little bit cynical on my part, but they actually used the words plumber and electrician a number of times throughout their decision to almost basically say that unless you're a business entity that has hired a plumber or an electrician to go and fix some part of your operational facilities, chances are the people that you're engaging to service you or some part of your business is going to be presumed to be that of an employee and not an independent contractor. So with that in mind, that's the backdrop. Let me just take a quick moment to give you some historical perspective here. The independent contractor doctrine is actually a judicial doctrine that developed back at a time when The courts, by and large, felt it was just that some measure of protection was needed when a hiring entity engages somebody to work or provide a service, but the hiring entity wasn't retaining the control over the day-to-day means by which that service was being provided. All they were interested in was the result. And under those circumstances where you're basically engaging somebody to provide that expertise and the control over the day-to-day process of doing the service, if a third party were injured by reason of that arrangement, it was just inherently unfair from the court's point of view, put the liability or exposure on the hiring entity, and that it should be the independent contractor who's responsible for any of those kinds of injuries. So it was a tort concept. It was intended to limit liability on that ground. Then at some point during the shaping of our country's industrial revolution, there was more and more of a concern that workers were being injured or other people were being injured, and the employers were depending on the basis that, well, this person was not employed by me. And I think that's one of the cases that got a lot of national attention was a child who was hired, I think, by his father to carry buckets of water to coal miners, and somehow in doing that got injured. It probably was not uncommon at that time for workers to supplement their income to bring on family members to help get work done at the place where they were working. And when that happened, I think there was just a mounting effort to try to reshape the laws and to say that it's not an answer for an employer to say, well, there's no formal employment relationship between me and this injured party, and therefore I can't be liable. And that's when you had a wave of statutes and regulations that were passed, and they were intended to help protect against child labor. And to make sure that employers were not able to just skirt their obligations by saying there's no formal employment relationship. So that's how you end up with the wage orders that exist today under the California regulations. Those wage orders have a expansive definition of employment, and they fall in three categories. One is an employer is defined as someone who has control over wages, hours, and working conditions. A second definition is one who permits or suffers someone else to be employed or to work. And the third is one who engages another to work. That's the common law employment relationship. And those three alternative definitions were put before the court in Dynamex, and the court focused on just that one alternative definition about permitting or to suffer to work when it talked about the ABC test. And the ABC test was applied in that case to delivery drivers who, and I guess this is one example of how bad facts make bad law, because the company in that case at one point had actually employed these drivers. They were on their payroll. The employer paid their taxes and acknowledged that they were employees, and then decided to make a shift in its business model. And they also freely admitted that the reason they made this shift to reclassify these drivers as independent contractors was to save money, or maybe to make more money. Depends on which side of it you're looking at, I guess. And the court, when it adopted the test, they adopted it specifically to Wage Order 9, which covered the transportation industry. But they also made it clear, and it's also pretty obvious, that because that the language in question that was at issue in Wage Order 9 also appears in many other wage orders. So it was understood that this holding was going to apply to all of the wage orders that had similar language about the employment test. So what is the ABC test? There are three parts to this test. I'm imagining most of the people listening here already have this firmly embedded in their thinking on it. First, the worker, in order to show that they're not an employee, the worker has to be free from the control and direction of the hiring entity in connection with the performance of the work, both under a contract and in fact. The second part of the test is that the worker has to perform work that is outside the usual course of the hiring entity's business. And by way of illustration, the court talked about the plumber and the electrician. And part C is that the worker has to be customarily engaged in an independently established trade, occupation, or business of the same nature as the work that's being performed for the hiring entity. All three of those conditions have to exist. If you don't have all three, then you are presumed to be an employee. And the burden is on the hiring entity to show that all three of these conditions exist. The burden is on the hiring entity to show that the person that they've engaged is an independent contractor, not an employee. And this, as you can imagine, is a very tough standard to meet, particularly with respect to Part B. The B prong is the most challenging one to avoid misclassification. The words of the court is basically you're going to have to show that the work that's being performed by this putative employee is not an integral part of the business. And again, I don't want to beat this to death, but it really struck out with me that the court did refer to some of the cleanest, simplest examples of the person who comes in to fix some plumbing fixture or electrical wiring at the employer's facilities. Again, the case examples that the court did talk about, in fairness, they did talk about a few other kinds of circumstances that they borrowed from other court jurisdictions. But this wording that I think warrants repeating here for the court to advance what they were trying to illustrate is an appropriate circumstance where one can say the person is being hired as an independent contractor. Thus, on the one hand, when a retail store hires an outside plumber to repair a leak in a bathroom on its premises or hires an outside electrician to install a new electrical line, the services of the plumber or electrician are not part of the store's usual course of business, and the store cannot reasonably be seen as having suffered or permitted the plumber or electrician to provide services to is an employee. Those are real simple illustrations, and in our industry, in the entertainment industry, when we start getting into the different kinds of people who are engaged to provide some input and service to some aspect of film production, it's just not that easy to try to see how something like this would even apply. Technically, Dynamex only addressed the issue of independent contractor status under the wage orders. After that, there were court rulings after Dynamex, excuse me for mispronouncing again, but between April of last year and up to the present time, there have been many cases, some published, some not published, that have been struggling with, does Dynamex apply to other circumstances that are outside of the actual wage orders? We know that the court's holding in that case was speaking specifically to wage order provisions such as minimum wage, time records, working hours, overtime requirements for non-exempt workers. But it does it does leave open, what about other provisions in the labor code? That was not part of the court's holding, and I think they even went so far as to say they were limiting their decision to those labor statutes that have some direct connection and is defined by the labor code regulations that are contained in the wage orders. So that kind of brings us to where our legislature followed up from there, and I'm going to turn it over to Alfredo to talk about what AB 5 is all about.
Thank you. So, as Jonathan stated, we were left in a situation after Dynamex of the courts trying to figure out and the legal community trying to figure out and struggling with the question of how far does the Dynamex ABC test go. The Governor Newsom in September of 2019 clarified that and expanded that to answer the question of the AB5 or the ABC test is now going to apply not only to the wage orders as Dynamex set forth, but also to other provisions of the labor code and also the unemployment insurance code and also the help me out, Jonathan, unemployment insurance and workers' compensation. That's right. So the ABC test is now going to apply much broader than what was originally intended, at least expressly intended by Dynamex. So that bill is going into effect on January 1st, 2020. What we want to talk about importantly in this webinar are the exceptions to the ABC test as set forth in AB 5. And one thing to keep in mind, it's an easy trap to fall into, and I'll remind you now, and I'll remind you again later, is when we're talking about these exceptions, it's not going to, the test is not intended to tell you whether a worker is an independent contractor and an employee. The test is only to tell you whether you're going to apply the ABC test or the Borello test, the multi-factor Borello test that we'll get to. So when we're talking about these exceptions and thinking about these exceptions, keep that in mind. Whether or not you fall into the exception doesn't answer the question of whether a worker is an independent contractor or an employee. That's going to be another step that you need to take. The most relevant exceptions set forth in the statute for, or as we anticipate that the exceptions are going to be relevant to the people listening to this webinar are contracts for professional services and business-to-business contracts. Those two exceptions are most relevant to the entertainment industry. There are further exceptions that we won't get into in detail, including certain California licensed professionals, lawyers and accountants, and less relevant exceptions, doctors, architects, commercial fishermen, etc. As I said, there are several exceptions set forth in AB5 and in the statute that AB5 created, and that we believe is simply a function of lobbyists getting to legislators' attention and convincing legislators that those exceptions were appropriate. We've reviewed the legislative history, and we'll talk about a little bit about some of those exceptions and some of that history as far as when we were able to convince legislators and when we weren't. Professional services, as I said, is one of the exceptions set forth in AB 5. That's a defined term, and it enumerates a list of, I believe, 11 occupations that comprise professional services. When we talk about the exception, the professional services exception, there are two parts to it. One is you have to fall into one of these 11 occupations, such as marketing services or administrator of human resources. But you also have to satisfy certain requirements that we'll get to. So to be clear, if you provide marketing services, that doesn't necessarily mean that you're going to fall into the professional services exception. You also have to be a worker provides marketing services and also meets the second part of the test that, again, we'll get to. So marketing services provided that the contracted work is original and creative in character, and the result of which depends primarily on the invention, imagination, or talent of the employee, or work that is an essential part of or necessarily incident to any of the contracted work. Some of that definition is going to be a little repetitive with the further requirements that we'll get to, and you'll see. Administrator of human resources, provided that the contracted work is predominantly intellectual and varied in character and is of such character that the output produced or the result accomplished cannot be standardized in relation to a given period of time. Again, that's directly from AB 5. There obviously is not any case law yet on AB 5 or the statute it created because it has not yet become effective. So once it becomes effective, we'll have more to go on as far as exactly how far these definitions extend and what the scope is of these various occupations. But for now, all we have to go on is the language of the statute as far as what it contains, and also the bit of legislative history. A couple of other professional services occupations that are listed are graphic design and fine artists. And as we say in this slide, the fine artist exception is undefined, but arguably can include singers, musicians, fashion stylists. I think that arguably can be bolded and underlined because there's quite a bit of doubt as to whether you can define fine artists that broadly. In fact, we looked at the legislative history of AB 5 and in particular the fine artist exception and saw that there were certain groups, including the RIAA, that proposed broader definitions either of fine artist or additional exceptions for different kinds of, for example, recording artists or songwriters that the legislature ultimately rejected. There's a couple of ways to look at that. One is that the legislature determined that no, we don't want an exception for those types of artists. All we want is fine artists such as sculptors and painters. Another maybe more or less broad view is to say that the legislature said actually the fine artist exception includes those other things, so we don't need to add additional language. I have my doubts as to that latter view, but it's something that is to be determined, and courts in the future will have to struggle with that question of exactly how far to read fine artists. So as I mentioned, the first part of the test is for professional services is determining whether you fit into one of 11 enumerated occupations. The second part is to determine whether the worker meets certain factors for the professional services exception. Those factors again are set forth in the statute and in AB 5, including the worker must have their own business location, which the professional services exception specifically provides may be the worker's home. Whether or not that may include a PO box is again undetermined as of yet. The worker must have a business license. Worker must be able to set their own rates, set their own hours outside of project completion dates, and must regularly do the same work for other companies or must advertise that they are available to do the same work for other companies. And the worker must exercise discretion and independent judgment in performing their work. All of these things are not or should not be surprising as far as trying to determine whether someone is an employee or an independent contractor. We put together some best practices for professional services that track the requirements that we just talked about. Obviously, the first best practice is to ensure that the worker falls within one of the occupations that are listed in the statute, such as marketing services, but also to request that the worker provide proof of a business license as is required, listing a business location, determining whether the worker performs similar work for other companies and whether they advertise foreign work for other companies, allowing the worker to negotiate their own rates and set their own hours, again, outside of the project completion date, which the hiring entity can dictate. And the hiring entity, while it may set the expectation for the final product to be delivered, should allow the worker to exercise as much discretion as is feasible in the process of actually performing the service. And if you comply with those best practices, you stand the best chance of falling within the professional services exception.
Just as a reminder, because when you look at these things frame by frame, it's hard to keep in mind what preceded. But to Alfredo's point, all of this has to be there, but also you've got to make sure that the person you're engaging who meets all these conditions is in one of those service contracts that meet the definition of a contract for professional services. Marketing, HR consulting, and those are the two that come to mind that might fit handily in a lot of what entertainment companies might be interested in having outside arrangements for. What about lawyers? Are they part of that group too?
Lawyers are part of it. It's certain California licensed professionals, so lawyers. But again, as a second reminder, just because you're a lawyer and you fit within these professional service requirements does not mean that you're then an independent contractor. It just means that you're going to be using the Borello Test to analyze whether or not you're an employment or whether you're an employee or an independent contractor.
Okay.
And that's a good segue to the next exception that we wanted to discuss, which is the business-to-business contracts exception, because this exception is much broader in the sense that there's not a enumerated list of occupations that a worker needs to fall into. Rather, you only need to fit the requirements, which are similar to the second part of the professional services contract or professional services exception test, and are set forth here in this statute. There is some uncertainty as to some of these, in particular, the second requirement that's listed. Jonathan is going to tackle that uncertainty a little more when we apply this business-to-business contracts exception and think about it in the context of loan-out companies, where loan-out companies, the most likely exception that they're going to fall into is this business-to-business contracts exception. So the requirements to fit into the business-to-business contracts exception are listed again in the statute, and we'll quickly go through them. The contract cannot be directly with the worker. The worker must have his or her own business entity, and the contract must be with that business entity. The hiring business entity must be free from the control and direction of the hiring company in connection with the performance of the work. The worker's business entity must provide services directly to a company and not to its customers. The contract must be written. The worker's business entity must have a business license and a business location. The worker's business must do the same type of work as the type in the contract with the company. The worker's business must regularly work for other companies and have its own clients without restrictions from the hiring entity. Jonathan will talk further about that, what we're calling the exclusivity requirement insofar as it affects loan-out companies. There's again uncertainty as to how broadly that requirement should be read. The worker's business must advertise to the public that is available to work for other companies. The worker's business must provide its own tools, vehicles, and equipment. The business must negotiate its own rates. The business must set its own hours and location. And the worker cannot be performing something that requires a contractor's license, electrical, plumbing, landscaping, etc. And this will be my third and final reminder about those exceptions that specifically that meeting the exception simply means that you're in the Borello test, and you can analyze whether someone's an employer independent contractor under that test, rather than going to the more stringent and harder to meet ABC test. So the exception only gets you halfway to where you want to go if you want to classify someone as an independent contractor. The Borello test, as a reminder, it's the test that's been around for some time in California. It's also called the Economic Realities Test. It came about in a case involving, I believe, cucumber harvesters, and the court trying to determine whether a company could fairly characterize these cucumber harvesters who were given full discretion as to how to go about picking cucumbers, but were only given discretion insofar as that very small piece. And as you might imagine, the court did not look favorably on classifying these people as independent contractors, where it said, for example, that there's only one correct way that someone could actually pick a cucumber, and then giving someone discretion as to that doesn't amount to a whole lot. The Borello case set forth several factors. None of these factors are dispositive, as was made clear then, has been made clear since. And the way the test works is to take all the factors and see how they interrelate to one another. So it's a squishy test, and by design, I think it's a squishy test, and gives courts quite a bit of leeway in determining whether someone is or an employee. The factors that some of the factors they mentioned included the right to discharge the worker at any time, whether the worker was engaged in a distinct occupation or business, the extent of supervision by the hiring entity, the amount of skill required in the worker performing the work he was to perform, who provided the tools, instrumentalities, and equipment, the method of payment, for example, hourly versus by piece, or and the party's belief as to the nature of the relationship. And again, there's no one factor that is dispositive. The Borello court and subsequent courts have made clear that even if you meet these factors, and these factors all point to a person being a worker, being an independent contractor, if you're simply allowing the worker to have unlimited discretion and control over a very small piece of the enterprise, that there's still a chance that they're going to be called an employee at the end of the day, because you don't want a situation, or at least the courts don't want a situation where that there's control over every piece of the enterprise, and someone is given a worker is given a very small role to fulfill, and is then classified as an independent contractor because they have discretion for that very limited role. And I'll turn it back to Jonathan to talk about loan out companies, and specifically how these loan out companies should how loan out companies should be viewed and analyzed as far as the AB5 exceptions.
And that is actually a good way to characterize what I'm going to discuss. There is no answer to this question. Are loan out companies considered to be within AB5's ABC test, or do they fall outside the test? If you go online, you're going to find articles that talk about both sides of that. And they talk about it in the same way that if you've been listening to any of those hearings that are going on today in Washington, you've got two sides just adamantly setting out their convictions about why one's right and the other's wrong. Part of the problem is that loan out arrangements have been in place in this industry, as you know, for many, many years. And when AB5 was on people's radars, a lot of artists, and I think their guilds and their unions, were looking at this question and understanding that if AB5 means that there's no such thing as a loan out company as far as the state of California goes, and recognizing relationships that are outside of a straight employment relationship, then that would be very disruptive. And if you, I believe in September, there was a joint letter that was prepared by SAG-AFTRA, I think the Teamsters, well, actually, I think I have it here. It's not part of our slide frame, but it's a short enough letter that it might even be worth talking about right now, if I can locate it. Yeah, here we go. It actually was issued September 19th. And the headline is, "The following is an important message from SAG-AFTRA, the Writers Guild, California IATSE Council, the Teamsters Local 399, Laborers Local 724, about California AB 5 and loan-out companies." And the letter says, "We're writing to you as guilds and unions of the entertainment industry." I think this was directed to their members. "We're doing so because there's a great deal of confusion about the potential impact of a new California bill, AB 5, on loan-out companies." And then it goes on to discuss, "Over the past 4 months, we've carefully monitored this legislation as it was drafted and moved its way through the legislature. And during that time, we conducted due diligence within our own guilds and unions with outside tax lawyers, CPAs, and entertainment lawyers knowledgeable about our business and loan-out companies, and with the legislative staff in Sacramento. And these conversations were all undertaken to ensure that AB 5 would not undermine the rights secured by our collective bargaining agreements, including the right to form and utilize loan-out companies." And they go on to further explain why the bottom line is members of our guilds and unions are not independent contractors, they're employees, but they can utilize loan-out companies, and that arrangement has not been disrupted by AB 5. And then they cap it off with, "This analysis is not a substitute for individualized tax advice. Some loan-out companies may have structural issues that put them at risk. This is not changed one way or the other by AB 5. Members should always consult their own professional staff advisors to ensure the optimal tax treatment of their earnings." Sort of like those drug commercials you see on TV, I guess, except not as long. But the point is that we have an organized effort by people who have an investment in this industry to look at that question of loan-out companies. And this letter that I made reference to actually talked about the business-to-business exception that Alfredo was just covering as one of the provisions by which we can say that loan-out companies survive the mandate in AB 5 that you would apply the ABC test. They would say that you don't apply the ABC test when you have truly a bona fide, legitimate company that is set up as a loan out, not to evade obligations, but for other legitimate business purposes. I will say that as a lawyer, if I were to defend that loan out companies are not affected by AB 5's mandate on when you apply the ABC test, it's because there are two published cases, California appellate court cases, and then there are a number of unpublished, or maybe there's even some published federal cases that have looked at the question of whether Dynamex applies, or whether Dynamex ABC test applies to the joint employment relationship. And the significance of that is because a loan out company, if it's a truly bona fide separate entity, they are engaging with a studio or some other hiring entity that wants the services of an individual artist. And if there's truly a separate business arrangement, separate contract by which the loan out company has agreed to lend the services of that artist to the studio, then there's an argument that at least meets the surface description of the business to business exception under AB 5, right? AB 5 doesn't expressly speak to joint employment. The arguments for applying it, though, is there is an affirmative statement in AB5 that its purpose is to prevent misclassification. Remember what happened in the Dynamex case is this transportation company or delivery company that used to have a workforce of employees that were actually delivering product that went to the core of the company's business, right? Then changed its business model to make them all independent contractors. And the allegation was, of course, that was a misclassification that now took a group of people and left them out in the cold unprotected by the labor code statute and regulations. That same kind of argument doesn't really apply to joint employer arrangements with loan-out companies if those loan-out companies otherwise pass legal muster under the federal tax laws. There are, I'm sure, people listening to this now who are much better, much more expert than I am on what those legal requirements are under the tax laws. But the tax laws, the federal tax laws, do recognize that a personal service corporation, and these companies come up oftentimes in the context of professional sports and in the entertainment industry with filmed entertainment product, those companies are recognized as companies that can legitimately be taxed as such and not have the tax pass on to the individual artists whose work, who might be loaned out by those companies. It gets a little complex on when and how that result will be recognized. I think there's something called the assignment of income doctrine that gave rise to the analysis back in the 1930s with the Supreme Court decision on when someone can actually escape individual liability for earned income, so to speak, that actually is being paid to that person's company as opposed to the individual worker. But the bottom line is that there is some recognition that that's a legitimate arrangement. And if it's legitimate for tax purposes, and if we keep in mind that the opening policy statement under AB5 was to, among other things, try to recapture revenue that otherwise is being lost by people, by business entities that structure these independent contractor arrangements, well, there's a fair argument to be said that loan outs don't really fall within the scope of what AB5 was intended to cover. Another point to keep in mind, it's one that was referenced in the Guild and Union joint letter I mentioned earlier. In this industry, loan out artists typically are covered and protected as employees because these artists are represented by guilds and unions and are covered by collective bargaining agreements, all of which, at least I'm not aware of any that don't have this, some provision that says that notwithstanding that the worker has a loan out company and is providing his or her services to that company, that worker will be entitled to, and the producer or the employer or the hiring entity who is signatory to the collective bargaining agreement must apply all the terms and conditions of that agreement to that worker, including payment of fringe benefits, making sure that they're paid for meal periods and overtime and all the other things that you would typically see in collective bargaining agreements. So those two things would help strengthen the argument that AB5 wasn't intended to cover loan out arrangements, but that only goes so far, I think, as you can point to workers who are in occupations or classifications that are traditionally under some guild or union contract. The ones that probably fall outside of that you have to take a very close look at are producers. Executive producers, associate producers, line producers, people that are considered part of the production management team. Some of them bring to the equation on a given production a lot of creative, visionary input on how the film product is going to be how the final product is going to look. Some of them are more technicians or more technically oriented and focusing on how to get that product to the place where the visionary wants it to be. But the bottom line is that anyone who is not covered by a collective bargaining agreement and who works in a production capacity at some management level, you still might be able to meet the business-to-business exception under AB5, provided that you meet all those criteria that Alfredo had mentioned earlier. So you've got to be very careful with those people who are not covered by a collective bargaining agreement to make sure that all the I's are dotted and the T's are crossed for that. I think it is important to keep in mind the distinction between the loan-out company that is contracted to provide the service and the artist who is performing the service. And by that I mean that AB5 was focusing on the unprotected worker in the same way that Dynamex was, the misclassified worker. But if you look at a loan-out arrangement as one in which you already have an entity that is employing the artist, and that entity being that artist's personal service corporation, that's where you can start with the right narrative to say why you don't believe that the ABC test should be presumed to apply to that person. I talked about federal tax laws in recognizing that loan-outs are a separate entity. There are certain conditions that have to be met. And again, the tax lawyers out there know this better than I do. But for one, you want to be sure there's a formal contract between the recipient of the service, that would be the studio in my illustration, and provided by the loan-out company. There should be an employment contract, not between the studio and the artist, but between the artist and his or her loan-out company. And it should be in writing. It doesn't, I don't think the tax regulations actually state this, and I think I've even gotten feedback from some tax advisors in the industry that say it doesn't have to be, but you really should probably put in place a formalized document to make sure you are really truly respecting the arrangement as an arm's length one. Alfredo had mentioned one of the criteria for the business-to-business exception for AB5 to apply is that the hiring entity must not have control and direction over the entity that is providing the service, and also that the entity that's providing the service can't be subject to some exclusive arrangement with the hiring entity. I don't recall exactly how the wording in the statute reads it. It was in one of the earlier slide frames, but those are things you have to be mindful about that might be a challenge here when we're talking about loan-out companies. This wording in this frame goes to the point of the business service provider having, the loan-out company, having to be free from the control and direction of the contracting business entity, i.e. the studio. And the troubling part is the language that follows from that. This is directly from the statute or from AB5. Must be free from the direction and control of the contracting business entity in connection with the performance of the work, both under the contract for the performance of the work and in fact. And what's troubling about that, of course, or what's challenging about that in the loan-out arrangement is that if a studio is engaging a loan-out company for the services of the artist, we all know that that artist is going to be on a day-to-day basis doing things, taking instruction from the studio representatives who are doing their production. And so I think the argument that you would be hearing from anyone who wanted to challenge whether this was an appropriate application of the exception would be that an artist who is engaged, even if the studio doesn't have control and direction over that artist's loan-out company, nevertheless is basically telling the artist what to do on a day-to-day basis, and that is where you walk into the part of this exception which puts them under the control of the studio under the contract in connection with the work under the contract. The person is providing services. As I mentioned, loan-out agreements typically include some form of contractual exclusivity during the term or duration of the service. I'm sure most of you are familiar with that. And that presents another challenge because the AB5 business-to-business exception, one of the criteria is the workers must be able to contract, again, these are direct words from the statute, actually contract with other businesses to provide the same or similar services and maintain a clientele without restrictions from the hiring entity. I think, but of course, I'm not the last word on it, and we won't know until there's been an actual challenge to this and the issue is actually put in front of a court or some other authority that has the final word on it. But I think a fair argument can be made that this provision does not somehow invalidate exclusivity clauses that you might have with an artist. It seems to me when you're engaging an artist for a limited time and they're providing service and they need to be sure that they can assure you that they don't have schedules that are going to conflict with the deadlines that you have, that's not a whole lot different from the true independent contractor arrangement where the hiring entity says, I don't really care so much about what you're doing for everybody else, but you need to be sure that the objectives and the end result of what I need from you is going to be timely met within the timeframes that we've discussed and contracted your service. So I think that's the kind of argument one can make to say that the fact that you might have an exclusivity clause with your artist or with the loan-out company who's providing the artist does not mean that you've now violated this one condition of the business-to-business exception. As I mentioned, the bottom line is that there are a couple of published cases. One of them came out literally just weeks after the Dynamex case came out. It's Curry versus Equilon. And then one came out just last month. We're still November, right? Yeah, just in October, Henderson versus Equilon. Very similar facts in both. In both cases, you had a plaintiff who was suing, and it might have been suing in a representative capacity or class action. I can't recall, but suing Equilon. Equilon, I think, is the formal name of Shell Company. I think that Shell Company's trade doing business as Shell Company. These employees were suing Shell because they claimed that Shell was liable to the failure to pay overtime, failure to do all the other things that the labor code requires in California. And the basis or the theory was that these persons were employed by another entity which contracted with Shell to manage and operate Shell's fuel stations, service stations. And I think these service stations not only, we've all been there. You go fill your gas up, but there's usually a convenience store selling drinks and sundries and things like that. So the primary employer was operating these service station and sundry stores. I think they were leasing from Shell and paying Shell, rent. And also, they would get a percentage or some fixed formula for their for the gas that was sold. In any event, there was no debate, no dispute that these employees were on the payroll of those fuel station operators. There was no debate or dispute that they took their direction from these operators. And in at least one of the cases, I believe the primary employer was being sued because they had basically treated this person as an exempt employee. The plaintiff was claiming he was not exempt, and that was a misclassification, and he should have been paid overtime and meal periods and all those other things. That operator, I believe, was insolvent. So, of course, what any good plaintiff's lawyer would do, they went around him and put Shell in their gun sights and said Shell was liable as a joint employer. And the short of it is, in both cases, both in Henderson and in Curry, the courts held that Dynamex really was not intended to cover the joint employment arrangement, because Dynamex involved a case where you had a group of workers who, but for their misclassification, were then left out in the code unprotected under the labor code. In a joint employment arrangement, you don't have that. So all of this is a long way of saying that one can fashion the argument that in the loan out arrangement, you at most have a joint employment relationship, one between the artist's company and the artist, and one between the studio and the artist, because the studio is actually controlling the day-to-day and giving instruction about what needs to happen in the course of that person's service. And with that argument, one could at least say that AB 5 was not intended to do anything other than codify Dynamex, and the case law that's out there already says Dynamex was not intended to cover joint employment arrangements. I don't know how well that argument's going to work, and we're not going to know unless it's challenged, and then of course we'll have to wait and see what the analysis is and how the holding comes out. That said, if you are going to, and I'm telling you from the feedback we're getting from most of our clients who are not going to say loan outs are through. You see that a lot online with articles, but the word we're getting is business as usual. But you want to be sure that you're at least taking a careful look at the business to business exception, maybe also the professional services exception, and doing your best to make sure that the conditions in your business arrangements where you are engaging someone through a loan out company line up with the things that are set out in those exceptions. You want to see that the worker provides proof of a business license if that's what's required. And it depends on the nature of the service. By way of example, let's say you've got some unique need for a very specialized pyrotechnic expert who is in the business. Maybe all of his or her job or the business's job is to lay out carefully orchestrated explosives for film settings. I assume that requires a license. You want to be sure that that person's company has that license. Be sure that there's a written contract in place with that company. You want to be sure that the license has a business location. We've got in parentheses not a residence. I'm not quite sure if that's really required or not, but it's always better if you have a separate place of business. The entity providing the services should do the kind of things that show that that is an independently established trade or business. Pyrotechnic company, in my example, fits nicely. It's a little bit harder, I know, with a lot of coming up artists, performers. But then with some, I'm sure there is a Bradley Cooper Entertainment Inc. or some equivalent of that out there, and that probably is in some form advertising entertainment services. I could be wrong, but obviously those are the kinds of things that put you more in a safe harbor. I know Beyonce has a separate company that actually loans her services out in not just her trade, but endorsing products and everything else that is tied to her name. The workers should provide services directly to the company, not its customers, and be able to negotiate their own rates, set their own hours outside of project completion dates. That one is going to be a tough one. And when possible or not impractical, you shouldn't have exclusivity provisions. Again, that's another tough one. Fortunately, there is something in AB 5 that says, we recognize that not everything here is going to neatly fit into some formulaic analysis. And when that happens, the court has the discretion to decide that ABC is not an appropriate test to apply in a given situation. And I don't think we actually quoted the portion of the statute that says that, but it's in there somewhere.
So we're right at noon. I see we still have quite a few people still with us. If people want to stick around just a few more minutes, Jonathan's going to talk about potential exposure and retroactivity, and then we'll wrap up.
Yeah, I think I run through it pretty quickly. So the ultimate question that clients are always going to want to have in front of them when assessing business risk about whether they want to change a practice is what is the exposure, or whether they decide not to change a practice that the statute might suggest they should be changing. What is the exposure? And for non-exempt workers, if you determined to have misclassified someone, you could be subject to a lot of labor code violations, violation of overtime premium requirements. There's liquidated damages when you fail to pay someone minimum wage or overtime. There are waiting time penalties if you fail to pay someone all the wages that are due and owed to the person at the time of termination. There are penalties for failure to have a statutorily required pay cycle. Usually it's biweekly or twice a month. Penalties for failure to maintain accurate, itemized wage statements. Penalties for meal and rest period violations. PAGA penalties. PAGA is the Private Attorney General's Act. Basically, a number of years ago, the legislature passed this law that said our labor commissioner is understaffed and overworked, and so we want to give private citizens the right to pursue claims as deputized labor commissioners to pursue violations of labor code violations. Penalties for willful misclassification of employees as independent contractors. Yes, there's a statute that was passed a number of years ago that says that if you're found to have willfully misclassified someone as an independent contractor, that's a misdemeanor, and you're subject to some penalties. I don't know what they are offhand. There are indemnity obligations under the Labor Code, Section 2802. You have to reimburse employees for all of the expenses that they would have incurred in the normal course of their employment for you. Penalties for the failure to withhold and remit appropriate taxes. For exempt workers, there are also penalties that you're subjected to. And this is something that a lot of people appreciate. There are labor code penalties, again, for itemized wage statements or failure to provide them, accurate ones. Waiting time penalties for failure to pay for wages at the time of termination or when due. Penalties for willful misclassification of employees as independent contractors. The same indemnity obligations I mentioned earlier. Same with respect to pay cycles. I believe with exempt people, you can be paid once a month. I can't remember exactly what the wording of the statute reads. And there's penalties from the failure to withhold and remit appropriate tax deductions. So these penalties presumably don't apply if someone's covered by a CBA, something we talked about earlier, that satisfies an exemption under a labor code statute or wage order. And there are several regulations and code sections of the code that actually exempt certain circumstances that otherwise would be a violation if you meet the coverage under a CBA that also includes certain conditions as outlined in those specific statutes. Retroactivity, I think we can summarize it by saying that as far as the ABC test applying to the wage orders that are tied, or I should say labor code provisions that are tied to a specific wage order, they are saying in the statute that that is simply a declaration of existing law as determined by Dynamex. Dynamex has yet to, or the Supreme Court has yet to rule on the question of whether or not Dynamex would be applied retroactively. I think as recently as last month, there was some case in which they've asked, the Ninth Circuit has asked that that issue be certified, but we don't know where the court is on that. The statute also says that as to those pre-existing definitions of employment or employer or employee as found under the labor code, the unemployment insurance code, or the workers' comp statute, those definitions remain in place and not disturbed by AB 5, which then means that you really don't get into the question of retroactivity because nothing really has been affected there. But for purposes of workers' comp, I'm not sure how or why that's there, but AB 5 states that the application of the Dynamex holding, the ABC test, is going to be deferred to July 1 of 2020. I think we have concluded.
We are concluding, yeah. So thank you for joining us. And if there are any questions, we're short on time here, but feel free to reach out to Jonathan or myself or anyone at the MSK Labor Department. We'd be happy to help you.
Thank you.